Hello and Happy New Year. We hope 2019 is off to a good start for you and that you are keeping safe and warm during this Arctic freeze. Welcome to this presentation from Vorys, Sater, Seymour, and Peace on the top 10 Ohio estate, trust, and probate law changes that will become law in 2019. My name is John Furness and I'm a trust and estate attorney with the Columbus office of Vorys. My co-presenter is Beth Weinwith, who is a fiduciary litigation attorney with the Cincinnati office of Vorys. We're pleased to have the opportunity to speak with you today. In the broader estate planning world, 2018 was dominated by the Tax Cuts and Jobs Act, which was hastily enacted at the end of 2017. Attorneys and other advisors adjusted to the new tax law provisions and eagerly awaited guidance from the Department of Treasury on these changes. Transfer tax exemptions doubled, now standing at $11,400,000 in 2019, but the doubling of these amounts will end in 2026. This provides clients with many planning opportunities in the meantime. Advisors also grappled with other aspects of the Tax Cuts and Jobs Act, such as the lower corporate tax rates, Section 199A deduction for pass-through entities, the limitation on the state and local income tax deduction, among others. In Ohio, 2018 was the last year of the 132nd General Assembly, and there was a flurry of activity after the elections in November during the lame duck session. In fact, as I understand it, approximately 40% of the 132nd General Assembly's legislative enactments were passed during that lame duck session. Among those bills that were enacted were a number of measures that impact Ohio trust, estate, and probate law. And Beth now is going to talk a little bit about the two bills that contain these significant measures.
Thanks, John. So the two bills that we're going to talk about today, and we're going to talk about the top 10 most interesting and notable changes that come out of these. This is by no means an all-inclusive presentation of every piece of legislation that was passed in this lame duck session. But the two that we're going to speak about today are House Bill 595 and Senate Bill 263. I want to let you all know that in the materials, the presentation materials, you do have links to the full document containing the legislative text for both House Bill 595 and Senate Bill 263. These documents show the red line changes, and they are a bit difficult to read through. So one of the slides that we have provided with these materials towards the end is a chart that cross-references the statute that is changed and the page number in the legislative text where you can find the red line. So as we move through this, you can follow along, or simply just know that you don't need to take exact notes of this as we move along. We are providing that chart to you for reference. So without further ado, the Omnibus Probate and Trust Bill, House Bill 595, was enacted December 13, 2018. The final effective date of this bill has not yet been announced, but we know it will be 90 days from the date, I believe, signed by the governor. So we're looking at March 21st, 22nd, and that date should become available on the Secretary of State's website in the coming days. But we can benchmark it pretty closely. House Bill 595 contains a sort of a grab bag of legislative changes, some of which have been in the works for several years, some of which came up only in the last few months before the bill went through the legislative process. A lot of the proposed changes were the work of or arose out of the Ohio State Bar Association's Estate Planning, Trust, and Probate Law Section Council and various committees that worked on those and proposed legislative changes and improvements. Others of them were not. For example, the changes to the Slayer statute that we're going to discuss and the Medical Records Access statute came forward through state legislatures directly. So moving along to Senate Bill 263, this one likewise was enacted in December 2018 and will be effective in March 2019, but certain provisions of it are not effective until September 2019. This is the Senate Bill 263 is the bill that speaks to the changes in the Electronic Notaries Act, which we will be speaking about. All right, folks, top 10 Ohio estate, trust, and probate law changes coming in 2019. Number 10, IOLTA account usage. That sounds very exciting, and that's why it's number 10. For those of you that don't know what an IOLTA is, and I expect most of you probably do, IOLTA, the acronym simply stands for Interest on Lawyers' Trust Account. Attorneys can create IOLTA accounts, and they are highly regulated by statute. They are accounts in which attorneys may hold client funds, and the interest on those accounts are go to the public interest of the state of Ohio's Indigent Defense Fund. So the changes to the IOLTA account usage statute, this is an interesting change that needed to happen. It really clarifies and essentially removes some legislative change that happened in March 2018. So pretty recently. Many Ohio practitioners assumed and used their IOLTA accounts as an efficient and inexpensive way to negotiate those small checks that came in after an estate account closed. For example, refunds, unclaimed funds, and it could be used as an efficient way to handle that. However, there was some doubt about whether or not that was actually proper, because Revised Code 2109.41 required that fiduciaries deposit funds received in an interest-bearing account in the name of the fiduciary. And so the reason for the change in March 2018 was to specifically set forth that the fiduciaries could deposit funds into attorney IOLTA accounts. But they overdid it a bit, it would appear. And what the changes in March 2018 did was they required that in order to do this efficient and helpful thing, the lawyers had to open a separate IOLTA account for each of the fiduciaries for which they were holding funds, and they had to receive court approval to do so. So the conclusion was that the intent of streamlining and making this process more efficient was not quite affected by those changes in March 2018. So what happened? They deleted those requirements. It literally just takes out Section B of 470509. So now it is clear that fiduciaries can have funds deposited in their attorney's IOLTA accounts, but they do not have to open a separate account, and they do not need to get court approval. John, number 9.
Number 9, the anti-lapse statute. Suppose that a testator's will provides, I give and bequeath to my son John the sum of $10,000. And suppose that son John does not survive the testator, but John's children, Jane and John Jr., do survive. If the will does not specify what happens in the event John fails to survive the testator, what happens to the $10,000 gift? Well, under the common law, the gift would lapse and the $10,000 would pass as part of the residue. In Ohio, though, there is a statute that addresses the situation. The statute is based on the presumption that, unless otherwise specified in the will, the testator would have wanted John's $10,000 gift to pass to John's surviving descendants per stirpes. Thus, under the statute, the gift to John will not lapse, and instead, a substitute gift of $10,000 will be made to John's children. This statute is called the anti-lapse statute because it keeps gifts from lapsing in certain situations. The issue addressed by House Bill 595 is whether that result should be any different if, instead of a gift to the testator's son John, the gift was made to the testator's children. As one of the testator's children, should John's share pass to his surviving descendants, or should it lapse? Under the Ohio statute prior to House Bill 595, unless a contrary intent appears in the will, the anti-lapse statute applies where all of the 3 following elements are satisfied. First, the will must provide a gift to a particular person or to a class of people, but not a class described as issue, descendants, family, or language of similar import. Second, the intended recipient of the gift does not survive the testator. And third, the intended recipient is a family member of the testator, which, for these purposes means that the intended recipient is either a grandparent of the testator, a descendant of the grandparent of the testator, or a stepchild of the testator. This language was at issue in a 2015 case, Castillo versus Ott, which involved a gift in decedent's will to, quote, "my children share and share alike, absolutely and in fee simple." The decedent was predeceased by one of his children, Roger Ott, but was survived by Roger's 3 children. The issue was whether the gift to Roger would lapse or whether it would pass to Roger's children under the anti-lapse statute. The court determined that the word children was similar to using the term descendants or family, and thus the anti-lapse statute did not apply. Many practitioners believe that this decision was contrary to the goal of the anti-lapse statute and sought a change. Accordingly, the Ohio State Bar Association adopted a proposal that modified the anti-lapse statute to provide that the only types of class gifts that are excluded from the anti-lapse statute are gifts to classes that include more than one generation, such as descendants and family. However, a gift to children is a gift to only one generation, and thus the anti-lapse statute would apply, thus overturning the result in Castillo. So anytime an anti-lapse issue arises, it serves as a reminder that an estate plan really should provide clear directions on what happens if a beneficiary is not living. And for fiduciaries who are administering estates and trusts, it is also a reminder to read the language of the will and trust carefully and understand what happens under Ohio's anti-lapse statutes if a beneficiary is not living. If the answer is not clear, the fiduciary should consider taking steps to resolve the uncertainty, such as through filing a declaratory judgment action. And that completes number 9. On to number 8.
All right. Number 8, the Slayer statute. House Bill 95 has included some changes that broaden the Slayer statute in Ohio. What is the Slayer statute in Ohio? The current Slayer statute in Ohio is found at 2105.19. It prevents someone who has murdered someone from benefiting from their victim's death, from their estate, from their life insurance proceeds, from their trust, any means of benefiting from the death. But the statute only enumerates the statutory violations, including murder, not involuntary manslaughter. And the new law broadens the statute to specifically include involuntary manslaughter. Now, you might be curious why this came to pass. And I do have some information on a real case that really, I believe, led to the motivation for this change to be provided. This was a case in which the husband killed his wife, immediately admitted killing her. It was a horrible fact, but pled down the charge to involuntary manslaughter, and the will gives him everything. Under the common law in Ohio has long prevented benefit to one who intentionally or feloniously causes the death of another. This is the Cotton case out of Franklin County. But in this case, the woman who was murdered's name was Joanne. In this case, Joanne's heirs had to do a lot of legal work to persuade the court that her killer should not take under the will. They had to sort of rehash the elements of proof, and this amendment fixes that. The exception that is contained in the change to this statute for vehicular manslaughter is to account for the scenario where you've got maybe a situation with a husband and a wife or a parent and child who are in a car accident, and one survives and would not want the surviving spouse or child to be cut out by this statute. So that is the change to the Slayer statute. On to number 7.
Electronic wills. One of the earliest cases addressing the issue of electronic wills was actually an Ohio probate court opinion from Lorain County in 2013. That case involved the purported will of Javier Castro, who, lacking a lawyer as well as a pen and paper in his hospital room, had used a Samsung Galaxy tablet and stylus to handwrite and sign a will. The requisite number of witnesses also signed. After Javier's death, the will was offered for probate, and all interested parties agreed that its provisions should be respected. In deciding whether to admit the will to probate, the question for the court was whether the writing was in fact a writing under Ohio law, and whether Javier had signed the will, which is also required under Ohio law. Ultimately, the court concluded that the term writing does encompass a document prepared on a Samsung Galaxy tablet, relying on a definition of writing used in an unrelated section of the Ohio Revised Code. And the court also concluded that the document was signed. And so based on these conclusions, the court admitted the will to probate. Since then, considerable attention has been directed to the issue of electronic wills. For-profit estate planning companies have been pushing legislation to make electronic wills valid. These companies, as I understand it, generally charge low rates for the preparation of a will, but collect higher rates for the electronic storage of the will. Legislative proposals have been advanced in a number of states. Indiana and Nevada now recognize electronic wills. Arizona has adopted legislation addressing electronic wills that will become effective later this year. And legislation has also been considered but not enacted in Florida, New Hampshire, and Virginia. In the case of Florida, the legislation was vetoed by then-Governor Rick Scott, citing concern regarding security and provisions that would open Florida probate courts to non-residents. Meanwhile, the Uniform Law Commission has formed an electronic wills committee, which is preparing uniform legislation that is intended to assist jurisdictions grappling with the issue of electronic wills. In Ohio, three primary camps seem to have emerged on the topic of electronic wills. The first one is comprised of those who believe that electronic wills should be permitted, either because they are inevitable or because they would actually benefit Ohio residents. A second camp consists of those who believe that electronic wills should be prohibited, citing concerns such as the integrity of the estate planning process and the protection of Ohio residents. And then a third camp is comprised of those who prefer to take a wait-and-see approach. These folks are inclined to wait and see what recommendations the Uniform Law Commission may make and to consider actions that other states may take on this issue before deciding on a course for Ohio. For now, the wait-and-see approach seems to prevail. However, in the meantime, Nevada has updated its electronic wills law. They did that in 2017. It did so in a way that poses a threat to jurisdictions like Ohio that are still grappling with the issue. Nevada now deems an electronic will executed by a testator who is not physically present in Nevada to have been executed in Nevada as long as either the witnesses or the notary public are in Nevada at the time of the online execution. So as a result, an Ohio resident from the comfort of his or her home could execute a Nevada electronic will online, and under Nevada law, that will would be deemed to have been executed in Nevada as a valid electronic will. Under Ohio's will recognition law, that electronic will could then be admitted to probate in Ohio since it complied with the law in the jurisdiction in which it was executed, even if Ohio would not otherwise permit it. Ohio has responded to this threat by amending its wills recognition law. Prior to the change, Ohio provided that a will shall be admitted to probate if the execution complies with the law at the time of the execution of the will in the jurisdiction in which it was enacted, or in which it was executed. With House Bill 595, the law now requires that to admit the will to probate under this provision, the execution of the will must comply with the law in the jurisdiction in which, quote, the testator was physically present when, end quote, it was executed. So in other words, the new law adds a physical presence requirement under this provision for admitting a will to probate. It should be noted there are other provisions for admitting a will to probate, but this is the only one that would really be applicable in this case. So as a result, an Ohioan, with this new change, an Ohioan who is in Ohio could not use the Nevada law to execute an electronic will and expect that will to be admitted to probate in Ohio. Thus, the threat from the Nevada law will be reduced. However, it should be noted that the threat is not entirely eliminated. That is, there is still the possibility that an Ohioan who is physically present in Nevada could execute an electronic will that could be admitted to probate in Ohio. I'm not sure we should expect a new ad campaign from the Las Vegas Convention and Visitors Authority promoting visits to Las Vegas to take advantage of its electronic wills laws. However, if people do execute an electronic will while visiting Nevada, it would be admissible to probate in Ohio, proving, I suppose, that not everything that happens in Vegas stays in Vegas. So that completes number 7. I think number 6 is the Notary Public Modernization, and I will speak to that one as well. So number 6, Senate Bill 263, dubbed the Notary Public Modernization Act, was introduced in 2017 for the stated purposes of simplifying and enhancing the system by which notaries public are commissioned and to allow electronic notarizations in Ohio. It was billed as a proposal that will allow Ohio to be a leader in utilizing technological advancements to innovate business practices. Proponent testimony was provided in the General Assembly by groups such as the Ohio State Bar Association, the Ohio Judicial Conference, the Ohio Society of Notaries, the Ohio Land Title Association, the Ohio Automobile Dealers Association, and even Quicken Loans. It passed unanimously in the Senate and passed the House by a vote of 77 to 10. The first major change in the law is that it eliminates county-by-county commissioning of notaries public and consolidates that responsibility with the Ohio Secretary of State. Henceforth, it is the Secretary of State that will grant commissions for notaries public. As part of its oversight, it will maintain an online database of notaries. The database will show for each notary a verification of the authority and good standing of the individual to perform notarial acts, whether the notary is registered to perform online notarizations, which we'll address shortly, and thirdly, a description of any administrative or disciplinary action taken against the notary. The new law also adds additional requirements in order to be commissioned as a traditional, as opposed to electronic notary. To be commissioned, an individual must generally satisfy 5 requirements. He or she must be 18 years of age. He or she must be either a legal resident of Ohio or an attorney who is admitted to practice in Ohio with a principal place of business or primary practice in Ohio. Third, he or she must submit a recent criminal records check report demonstrating that the individual has not been convicted of or pleaded guilty or no contest to a disqualifying offense, which is generally defined as a crime of moral turpitude. It should be noted that this third requirement does not apply to attorneys, and while some might try to make a lawyer joke out of that exception, the reason for it is that the criminal record of an attorney would affect the attorney's ability to practice law in the first place. The fourth requirement, he or she must successfully complete an educational program. This program, it should be noted, will not apply to attorneys who are already notaries. However, it will apply on a going forward basis to attorneys who are not already notaries. And then the fifth requirement is that the applicant must pass a test, which is another requirement that does not apply to lawyers. The new law also provides more guidance with respect to notarial acts. It sets forth additional detail on how a person may make an acknowledgement or an oath or affirmation. It also includes a list of prohibited actions, most of which are self-evident but are now made express. Another noteworthy feature of the new law is that it authorizes notarizations for persons physically unable to sign, an issue which arises more frequently than is sometimes realized. I've had, for example, 3 or 4 questions in the last 5 months about that type of issue, and this will now provide some guidance. The new law provides that an individual whose physical characteristics limit his or her ability to sign a document presented for notarization may direct a designated alternative signer to sign on the individual's behalf if certain requirements are satisfied. Finally, the new law provides an alternative to a face-to-face notarization by offering electronic notarization. Under the Act, a notary who is specially authorized to provide electronic notarizations can notarize a document even though the signer is not in the physical presence of the notary, provided that the notary and the individual can interact by means of a live, two-way audio-video communication. The notary can perform any notarial act as an online notarization other than taking or certifying a deposition, and an electronic document notarized through an online notarization is considered an original document. To perform online notarizations, an authorized electronic notary must be a resident of Ohio and must be in Ohio at the time of the online notarization. As for the signer, he or she generally must be located in the United States, but can be located outside the United States in certain situations. In order for an electronic notary to perform an online notarization for someone outside the United States, the act must not be prohibited in the jurisdiction where the signer is physically located, and the record being notarized must have some connection to the United States. There are procedures for verifying the identification of the signer. It includes not only the production of government-issued identification, but also a credential analysis of the identification credentials and identity proofing of the signer. The online notary is required to maintain a complete recording of the audio-video communication that is the basis for identification of a signer for each online notarization. An online notary is also required to maintain an electronic journal recording detailed information on every online notarization performed. On the expiration of the electronic notary's 5-year term, the electronic journal must be given to the Secretary of State, who will maintain it for 10 years. While the electronic journal is in possession of the online notary, the notary must make it available to anyone who makes a specific request for inspection. There are certain exceptions for this. For one, the online notary can deny the request if he or she has a reasonable and explainable belief that a person requesting information from the notary's journal has a criminal or other inappropriate purpose. Also, an attorney's obligation to allow inspection is more limited and may be denied altogether on the basis of the attorney-client privilege where applicable. So how does someone become authorized to provide electronic notarizations? Well, any commissioned or traditional notary may become an electronic notary by taking 5 steps. First, paying an additional fee. Second, submitting an application to the Secretary of State disclosing, among other information, the technology that the applicant intends to use in performing online notarizations. 3, taking a special course on the rules, procedures, and ethical obligations imposed by the statute. And 4, passing an examination based on the course. These new requirements will also apply to attorneys. And if I said there were 5 requirements, I meant 4. Those are the 4 right there. And again, they apply to attorneys in the same way as non-attorneys. An authorization to perform online notarizations will expire after 5 years, even for attorneys. To renew, the electronic notary must pay a fee, submit a renewal application, and complete continuing education requirements. If you miss your renewal deadline, you have to go through the whole process as though you'd never been licensed in the first place. Additional details on how electronic notaries will operate will be provided in future regulations issued by the Ohio Secretary of State. All these changes will become effective in September of 2019, and it will be interesting to see how many notaries will seek to become authorized to provide electronic notarizations. The requirements and procedures do seem burdensome and onerous, but it is likely necessary to ensure the integrity of the method of notarization. So that is a summary of that law, and we are now moving on to number 5, I believe. Beth?
All right. Of our top 10, we are now at number 5 at 12:30. We are halfway there, folks. All right. The next statutory change that we'll be talking about is actually an entirely new statutory procedure involving access to medical records of a decedent without opening an estate. This statutory change was not one that came through the Estate Planning, Trust, and Probate Law Section Council. This one was brought forth by Representative Rezabek, and we did have, there was some opportunity for some folks to comment on it, but this one did come through pretty quick towards the end of 2018. What it does is it specifically sets forth that any person who is eligible to be appointed as a personal representative of an estate may file an application with the probate court in the county in which the decedent resided, seeking release of the decedent's medical records and medical billing records for use, and the statute specifically says, for use in evaluating potential wrongful death, personal injury, or survivorship action on behalf of the decedent. This is interesting in that there is in the statute a specific limitation as to the use of these medical records being sought. As a litigator, I found it interesting that you cannot, at least according to the statute, seek these records for example, evaluation of a will contest. So that's an interesting piece of this new language to note. The application, however, has to be accompanied by a form listing the decedent's known surviving spouse, children, next of kin, all the folks that would be on your typical Form 1.0 when you're opening an estate. And the court can give this access to medical records with or without holding a hearing. But there is a requirement that the court not do so until 10 days after these next of kin are notified. So this is going to be an interesting new process to see how this works, how this is used by folks who are looking to get medical information about folks who are deceased without opening an estate. It will be interesting to see how this one goes, but this is an entirely new statutory procedure and that we should all be aware of. Moving on to number 4, which I have titled the Incorporation by Reference Fix. This change is going to be found at Revised Code 210705, but this one requires a little bit of backstory. So there was a case that came out in 2016, the Gerke versus Sinq case. And in that case, the plaintiff wanted to contest an inter vivos trust only, not the will of the decedent. But the court held that in that case, because the will referenced the trust, the party needed to file a will contest within the statute of limitations period to contest a will, which is 3 months, as opposed to the 2-year statute of limitations for contesting an inter vivos trust. Many practitioners found this to be concerning. It was referred to as a statute of limitations trap. And so a committee was formed to look at this and to determine whether and how some changes might be necessary to clarify this issue. Under the old law, any contest to an inter vivos trust that was named in the will had to be filed within the 3-month period to contest the will, or under Gerke, which cited an Ohio Supreme Court case, the Hageman case, or it would be barred, and in fact was barred in the Gerke case. So the change is very simple. The change to the incorporation by reference statute simply adds language to say that any language in a testator's will that only identifies a trust shall not be sufficient to manifest an intent to incorporate that trust instrument by reference in the will. The problem with the Gerke case that alarmed many practitioners was, rather than, this was not a situation where the language in the document said, if the trust into which this will pours is found to be invalid, I then incorporate the trust by reference into this will. This was not the language. The language involved in the will in the Gerke case and in the Hageman case was language that practitioners would refer to as pour-over language, standard pour-over language. It simply said that the assets are to be distributed to the trustee of my trust. And so what the Gerke case did was basically change the way most practitioners were thinking about incorporation by reference language. And it was being interpreted by the courts to do something different than what was intended. So by adding this new language to the incorporation by reference statute that specifically provides that if you're incorporating a trust by reference, you have to use very specific language, what that does is that then makes clear that the statute of limitations for contesting the validity of an inter vivos trust remains the 2 years under revised code 580604, and an attorney who is looking to, on behalf of their client, contest only a trust can know for certain that they are not going to be trapped into missing a statute of limitations because of the language in the Gerke case. This is very important, especially in cases where you may have a will that there are no facts to contest the validity of the will. The will may have been executed many years before the trust that is at issue. And so until this statutory fix becomes effective, practitioners still need to be concerned and aware that they may need, in fact, to file something, a will contest to preserve claims under the statute. It is important to note that this fix, as drafted and as adopted in House Bill 595, is not retroactive. The language is explicit that it applies only to the wills of testators who die on or after the effective date of this amendment. So if there is a situation up to the effective date of this statutory change, the practitioner will still need to be aware of this Gerke case and of the potential need to file in advance of the 3-month statute of limitations for will contest.
Okay, coming down the stretch here, number 3, pre-death trust validation. Given the uptick in fiduciary litigation, it behooves estate planners and their clients to consider the likelihood of a challenge when preparing wills and trusts. The potential for such challenges may affect some of the substantive aspects of the estate plan and may influence its implementation. For example, if there's a concern about a challenge, a testator may consider including a well-crafted interiorum or no contest clause, which provides that the interest of a beneficiary and possibly even the beneficiary's descendants would be forfeited if the beneficiary initiates a challenge. When such a provision is combined with a gift to the potential litigant risks losing his or her gift by initiating a challenge and is forced to think twice before proceeding. Another alternative that has been available in Ohio since 1979 is a procedure whereby a testator can initiate an action in probate court during his or her lifetime to have the testator's will declared valid. If declared valid, the decision is binding, thereby avoiding costly and damaging will contests after death. Despite the availability of this alternative, it has not been widely utilized, due in part to certain limitations or possibly deficiencies in the original statute. For one, the Act did not apply to trusts. Thus, a testator could establish the validity of his or her will, but if the testator's trust was the beneficiary under the will, the testator could not establish the validity of that trust, leaving open the door for contest related to the trust after the testator's death. Another limitation under the Act made it cumbersome to modify or revoke a will that had been declared valid, requiring that such modifications or revocations utilize the same pre-death validation procedure. This prevented testators from being able to adjust estate plans nimbly in the future. These particular limitations have been eliminated by House Bill 595, which repeals the existing procedure and replaces it with a new and improved procedure that also applies to trusts. This new procedure has been codified as Chapter 5817 of the Ohio Revised Code. Under the new statute, a testator may file a complaint during his or her lifetime for a determination that the testator's will is a valid will. Now, though, if the will names a trust as a beneficiary, and if the testator is the settlor of that trust, then the complaint can, and in fact must, request the determination of the validity of the trust also. In addition, the new statute permits a settlor to file a complaint during his or her lifetime to determine that the settlor's trust is valid and enforceable under its terms. This right to initiate such a procedure is personal to the testator or settlor. It cannot be exercised by a guardian or by an agent or attorney in fact acting under a power of attorney. These actions are commenced by the filing of a complaint in probate court, like any other civil action, and must be served on the defendants. The statute requires that the filing of the complaint be accompanied by an express written waiver of the testator's physician-patient privilege, so that the medical records of the testator or settlor can be accessed. The statute also sets forth the necessary parties who must be named as defendants in the action. The parties depend on whether the action relates to a will only or a trust only, or both. In any action, whether for a will or a trust, the parties must include the testator's or settlor's spouse, children, and heirs as determined under the Ohio laws of intestacy as of the date of the complaint. If the action involves a will, additional parties would include the beneficiaries under the will, as well as any beneficiary under the testator's most recent prior will. If the action involves a trust, additional parties include the trustees, the beneficiaries under the trust, including both current and remainder beneficiaries, and any beneficiary, whether current or remainder, under the settlor's most recent trust. The testator or settlor has the option of naming additional parties who may have a pecuniary interest in the determination of validity. After a complaint has been filed, the court sets a time and place for a hearing. The hearing is adversarial in nature. If the action stays in the probate court, the judge may determine all questions of fact, or the judge may order questions of fact to be tried before a jury or determined by a special master commissioner. The testator or settlor has the burden of establishing prima facie proof of the proper execution of the will or trust. A party opposing the determination has the burden of establishing either lack of testamentary intent or the intent to create a trust, lack of requisite capacity to execute the document, undue influence, restraint, or duress on the testator or settlor, and or fraud or mistake in the execution of the will or trust. If a court declares the will or trust valid, no person may contest the validity of the will or trust. However, if a person who is a necessary defendant was not named or was not properly served, and if that person is not properly represented by another defendant, then that person is not bound by the order and may contest the will or trust. Thus, careful attention must be paid to the naming of defendants and service of the complaint. Unlike the prior law, the new statute allows a will or trust previously declared valid to be revoked or modified without following the pre-death validation process, though that process is certainly still available if desired. It will be interesting to see how many Ohio practitioners will utilize this procedure after it becomes effective in March of this year. Certainly, there are a number of potential advantages. For one, it would allow questions of validity to be resolved while the settlor or testator is alive and thus available to provide the best evidence related to capacity, undue influence, and the like. Further, this procedure may deter potential litigants from challenging a will or trust that they would be more likely to challenge after the death of the testator or settlor. For example, a beneficiary may be concerned that his or her challenge may cause the testator or settlor to eliminate or reduce the interest of that beneficiary in the estate plan. Further, a beneficiary may not have the financial incentive or financial resources to engage in a dispute when it may still be many years before any benefit is realized. Of course, it could be argued that this practical reality may also deter legitimate challenges. There are also disadvantages that should be weighed with the procedure. For one, the procedure requires a testator or settlor to incur expense to avoid the expense of a future challenge that may not have ever actually materialized. Moreover, the procedure could cause a major disruption within the family that will be on full display for the testator or settlor, which may take a significant personal toll on the testator or settlor. The procedure also results in a loss of privacy for the testator or settlor with respect to the contents of his or her estate plan and may put family dysfunction clearly in the public eye. Further, the effects of the procedure may be negated by subsequent amendments or revocations that may not utilize the procedure. In other words, while the ease of subsequent changes to an estate plan is a positive attribute of the new law, it could also serve to undermine its value. So these and many other advantages and disadvantages will affect the extent to which this new and improved alternative is actually utilized by settlors. So that completes number 3. Number 2 on our list is trust arbitration. Arbitration, as many know, is a way of resolving disputes that is an alternative to traditional litigation in the courts. It is commonly required under business and contractual arrangements as a way to avoid costly, time-consuming, and very public litigation. Under the Ohio Revised Code, with certain exceptions, a provision in any written contract to settle by arbitration a controversy that subsequently arises out of the contract is valid, irrevocable, and enforceable. In applying this provision, the Ohio Supreme Court has recognized that arbitration is encouraged as a method to settle disputes. It stated, quote, "An arbitration clause in a contract is generally viewed as an expression that the parties agree to arbitrate disagreements within the scope of the arbitration clause, and with limited exceptions, an arbitration clause is to be upheld, just as any other provision in a contract should be respected." While the use of arbitration is generally favored under Ohio law, the enforcement of arbitration provisions is limited to persons who have specifically agreed to arbitration. The Ohio Supreme Court has stated that, quote, "There is no dispute that arbitration is a matter of contract, and a party cannot be required to submit to arbitration any dispute which he has not agreed so to submit," end quote. There have, though, been exceptions where arbitration provisions have been found to bind persons who are not parties to the agreement in certain situations. For example, a recent case from the 8th Appellate District held that an arbitration clause under an IRA client agreement could bind persons who claim to be the designated beneficiary of the IRA. The application of these exceptions to a trust is unclear. The uncertainty arises in part from the unique nature of trusts, which are legally distinct from other relationships, such as contracts. Prior to the enactment of House Bill 595, it was at the very least debatable whether a trust instrument could compel the beneficiaries to resolve disputes by arbitration. With the enactment of House Bill 595, though, Ohio resolves this uncertainty and becomes the 5th state to adopt a statute that specifically provides for the enforcement of mandatory arbitration provisions in trusts. House Bill 595 enacts a new section 5802.05 of the Ohio Revised Code, which provides that the terms of a trust requiring the arbitration of disputes between or among the beneficiaries and a fiduciary, or any combination of such persons or entities, is enforceable. There are only 2 exceptions to this provision. First, it does not apply to testamentary trusts, which are trusts established under the terms of a will. And second, it does not apply to disputes of the validity of all or a part of a trust. The change is exciting and intriguing. For one, it resolves the uncertainty that previously surrounded arbitration clauses in trusts. Moreover, the statute provides settlors with an additional tool to customize their estate plans. In the event a dispute arises under a trust, a settlor can now dictate who will resolve the dispute, how the process should be structured, and how it will be paid for. As such, a settlor can enhance the privacy of his or her estate plan and family circumstances, ensure that disputes are resolved by persons with credentials in line with the settlor's intent, and potentially reduce the costs and delays associated with traditional litigation. In addition, the use of arbitration may be particularly attractive to professional trustees, such as trust companies. When disputes are resolved in the courts, the resolution establishes precedent that affects the resolution of subsequent disputes. When disputes are resolved by arbitration, however, the results are private and do not establish legally binding precedent. Thus, arbitration may be a way to lower risks to corporate fiduciaries in resolving disputes. With the adoption of new revised code section 580205, Ohio state planners will need to become familiar with the use of arbitration to resolve disputes. The choices that are available in structuring an arbitration clause and the circumstances where an arbitration clause would further a client's estate plan. Some of these drafting choices are set forth on the slide, and the first issue is defining the type of dispute that should be settled by arbitration. With the exception of disputes related to validity of a trust, any dispute that arises under a non-testamentary trust may be settled by arbitration, whether the dispute is between or among beneficiaries in a fiduciary or any combination. An arbitration clause should address whether arbitration must be used for all types of disputes or whether it will be utilized in only more limited circumstances. Another choice is the selection of arbitrators. An advantage of arbitration is the ability of the settlor to control the selection of arbitrators and ensure that disputes are resolved by appropriate persons. A settlor may wish to use an arbitrator who possesses certain skills and expertise, or an arbitrator who shares certain religious or cultural values. An arbitration clause should address how the arbitrators are to be selected and what credentials they must have. Costs are another consideration. While arbitration can be less expensive than traditional litigation, it is certainly not without cost. An arbitration clause should address how the expense of arbitration will be paid and, to the extent paid from the trust, how it will be apportioned among the beneficial interest in the trust. An arbitration clause could also provide for fee shifting in certain circumstances, similar to the power that a court has under the Ohio Trust Code. Confidentiality. Many settlors have a strong interest in confidentiality, and arbitration is another tool to protect that interest. An arbitration clause could require that the persons interested in the trust keep the arbitration proceedings confidential. It could even attempt to impose consequences for violations of that confidentiality. Settlors should also consider what procedural rules will be used in the event of an arbitration. An arbitration clause may require the use of a particular arbitration forum that has its own set of procedural rules, such as the American Arbitration Association, or may allow the parties and or the arbitrators to decide upon the rules. There are a lot of potential uses for this new statute, and anticipate that arbitration will become a more frequent format for resolving trust disputes when inevitably they arise. And that's when we'll need the help of Beth, folks who are our fiduciary litigator friends. Beth, for the final entry on our list.
Number one, the number one on my list at least of the changes in House Bill 595 is the protection of the fiduciary attorney-client privilege. There is tension as to whether or not a fiduciary has to provide, and what information a fiduciary has to provide to beneficiaries of a trust under the statute that requires a trustee to keep beneficiaries reasonably informed of all information necessary to protect their interests in the trust. And, of course, the important ability of a fiduciary to seek counsel and to feel free to speak freely with that counsel and without the fear that their conversations, their emails, their discussions will be later disclosed to beneficiaries if litigation ensues. Before 2017, the law that most attorneys believed covered this situation was found at 5815.16. This statute reads, absent an express agreement to the contrary, an attorney who performs legal services for a fiduciary by reason of the attorney performing those legal services for the fiduciary has no duty in obligation in contract, court, or otherwise to any third party to whom the fiduciary owes obligations, such as beneficiaries. There was, it seemed, general consensus that this statute protected the attorney-client privilege, and a majority of courts before 2017 did not apply what's called a fiduciary exception to the attorney-client privilege. In other words, In other words, if you're a fiduciary and you owe duties to beneficiaries to inform them of everything affecting their interest in the trust, there was an exception to the attorney-client privilege, and they could get access to that information. Trustees were typically not forced to disclose privileged communications in litigation with beneficiaries. I'm aware of a matter down in Hamilton County Probate Court where in 2017, a motion to compel on this basis was denied. In 2017, however, a case came out in the 8th District Court of Appeals, Duke versus the Clifton Colony Club. In this case, the court applied a fiduciary exception to the attorney-client privilege and ordered privileged documents to be provided to beneficiaries who were in litigation with the trustee, citing the duty to inform and report under RC 5808.13. As you might expect, this caused some discussion among practitioners in Ohio, and some real concern as to what was and was not subject to the attorney-client privilege when attorneys are representing fiduciaries. And so a committee was formed to take a look at this and to propose and draft some legislation. That was done. That was, in fact, able to be added into this House Bill 595 within the last few months. And so it was in fact, we do have this protection now. What has been added to 5815.16 is an entirely new section that just makes this perfectly crystal clear in case there was any question, which obviously there was. The new language reads, any communication between an attorney and a client who is acting as a fiduciary is privileged and protected from disclosure to third parties to whom the fiduciary owes fiduciary duties to the same extent as if the client was not acting as a fiduciary. So just in case there was any question, there now no longer is, at least as of the effective date of this new House Bill 595. So that is an important development for all fiduciaries and the attorneys who represent them. All right, we're coming right up to the end of our hour. We did want to provide to you in these materials and some references if you want to dig deeper on some of these, on the background of how they came to be, and of course the link to the legislative text. We have included the entire text in the materials for you, but here are the links to the legislative text if you want to keep tabs on them. And then also some references to some probate law journal articles that really provide some great analysis of all of these items if you want to go a little deeper. And finally, as promised, a chart that will spell out for you by topic, statute, and the legislative text page number. If you want to just keep this in your desk drawer and refer to it whenever these issues might arise for you, we're happy to provide this to you. So that concludes our presentation, although do we have a couple of minutes?
Yeah, we thought we just might also preview some things that we expect to see in 2019 as well. So these are some items that are being worked upon by a number of very talented lawyers, some of whom I see on this webinar. So thank you for all your hard work. One I'm going to mention real quick is that at the Ohio State Bar Association's Estate Planning, Trust, and Probate Law section, a committee is working on coming up with an alternative for establishing finality for a trustee when a trust is terminating or when the trustee is exiting that relationship, whether through removal or resignation. This would be an optional procedure, and is really intended to be an alternative to the release and indemnification agreements that trustees often request when, again, the trust is terminating or the trustee is resigning or has been removed. So this statute is based on a Kentucky statute, but is no doubt being improved upon by this august committee that is working on this proposal. So it's moving pretty quickly and pretty well, and I wouldn't be surprised if we see that advance to during 2019.
And one other piece that's being worked on is some proposed clarifications to the presentment statute. There was a case that came out recently, the Wilson versus Lawrence case, which raised a little bit of question as to what counts as presentment when you're presenting a claim to the executor or administrator of an estate. And there is a committee working on some language that will clarify that and help folks to have no question whether or not they have in fact presented their claim within the 6-month claims presentment period. So keep an eye on that coming in 2019, hopefully.
And so we'll see you all back in January of next year to see what happens during 2019.
Yes.
This concludes our program. Thank you for joining us.